The hearing in Elena Ruiz's left ear never came back, and when I said her name after sentencing, nobody moved. I remember thinking that a courtroom can punish a choice and still fail to return what a person came there hoping to get back. That was the silence I carried home. I want to tell you how I arrived there. Subscribe, not for me. For the reason I am telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. The first time Elena Ruiz came into my courtroom, she did not move like a person asking to be saved. She moved like a person already adjusting herself to damage. She was 42 years old, a public school music teacher, and she kept her right shoulder angled toward whoever was speaking. A careless eye might have missed it. I did not. Later that morning, while two lawyers argued, she touched the base of her throat with two fingers and counted quietly to herself. It was how she steadied her voice before another stranger asked her to make her changed life sound simple. The defendant, Daniel Mercer, was 34, well-dressed, and practiced in the kind of calm that can look like innocence from a distance. He rarely looked at Elena. He looked at counsel, at the clerk, at the clock, and at the side door. He straightened his cuffs whenever a hard fact landed. I will tell you one thing I saw in him. On the second day when his mother entered from the back, he rose halfway before anyone told him to stand. For 1 second he was not a defendant, he was only a son. That made it worse because it told me he knew how to recognize a person and still failed to do it when the moment asked. The incident happened on Friday, October 18, 2024, at 7:42 in the morning, at the corner of Harbor Avenue and Linden Street in Riverton. It was raining lightly, the school zone lights were flashing. Elena was walking her bicycle through the marked crosswalk because she had learned that traffic at that hour ran too tight for trust. Daniel Mercer was driving a Black Veil Air Systems sedan assigned to Adrian Vale, a billionaire whose name carried pressure in that city. In testimony, the crossing guard, Pauline Vega, said Daniel rolled down his window and said, "Mr. Vale does not sit in traffic." Nobody in that courtroom needed help understanding him. There was no evidence Adrian Vale ordered him to break the law. That mattered, and I kept it separate, but Daniel used that name like a permit. He drove around the school drop-off line, put two wheels over the curb, clipped the front wheel of Elena's bicycle, and struck the left side of her head with the side mirror hard enough to throw her down. A parent said Elena tried to stand, then sat back on the wet pavement and said, "Something is wrong with the sound." Daniel got out. Another witness said he looked first at the rear passenger door, not at Elena. Then he said, "I only put two wheels on the curb." Quiet words, still wrong. The ambulance log, the body camera footage, the bent front wheel, and the dispatch record from 7:43 a.m. came to me later in neat order. The law prefers that. Human harm does not. By the time the file reached my desk, the law had names ready for what happened. None of those terms named the missing left side of a music teacher's world. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe. Stay with it. What first crossed my desk was the complaint, then the amended charge, then the medical summary from St. Anne's Trauma Unit. Let me put this plainly. Guilt and sentence do not travel together. First, I decide what the evidence proves. After that, and only after that, I decide what response the law allows. Between those two steps, there is a distance that looks small on paper and feels wide in court. In Elena's file, the line that made me stop was not long. It said, "Permanent sensorineural hearing loss, left ear, unlikely to resolve." There was another paper under it, a payroll statement. Elena had used 5 sick days in 2 weeks and then returned to work because pain does not stop the rent. There was also a note from her principal, handwritten in blue ink. It said, "Classroom microphones requested." That note was not evidence of guilt, but it showed me the gap between what the law could name and what daily life now required from her. I could decide what the law allowed me to do. I could not give her back the ear she lost. From the bench, I see entrances in a way few others can. Elena entered on the first day with her brother one step behind her, but she stopped before counsel table and let him pass around to the far side. Most people did. I did not. She wanted the speakers on her right. She set her bag down slowly, touched the back of the chair once before sitting, and when the clerk read the case name, she did not look at Daniel Mercer. She looked at me with the face of someone prepared to be exact. Daniel's entrance was different. He came through the side door with his lawyer, and before he sat, he glanced at his reflection in the dark monitor screen on counsel table. It was not vanity, it was habit. He had spent enough time near important men to learn that looking composed can pass for being blameless. Then he sat and kept one hand near his tie, as if his body still believed it was protecting a job, not answering for a harm. There were 3 moments when the room went completely quiet. Not the ordinary pause between questions. Not the soft stop while somebody found the right page. I mean the kind of quiet that settles when something true has entered the room and nobody knows what to do with it yet. I remember this case by those silences now, not by exhibit numbers or docket entries. Before the first silence, the facts came in the steady way facts often do, one piece at a time. Pauline Vega testified. The trauma doctor testified. A city worker brought in photographs of the curb marks left by Daniel's tires. A traffic engineer explained why the school zone lights were active. Then Elena took the stand. She was sworn in, thanked the clerk, adjusted the microphone once, and when the prosecutor asked how the injury had changed her work, she said, "I still teach music, Your Honor. I just do it with one side of the room gone." That was silence 1. I cannot tell you the exact number of seconds because nobody counts silence with a watch. From the bench, it felt close to 8 seconds. Nobody shuffled paper. Nobody coughed. Even the court reporter's hands rested. The quiet after Elena's sentence was not confusion. It was recognition. Then the prosecutor cleared her throat and asked the next question. After silence 1, I understood something the medical report had not fully delivered. Hearing loss is easy to flatten into a term. What Elena gave me was a room cut in half, a classroom, children singing, instructions missed, heads turned, a life in sound altered by force. That was when the case stopped being only about a curb, a mirror, and a bad choice. The physical evidence matched her account. The sedan's telematics showed 29 miles an hour in a 15-mile school zone, 5 seconds before impact. Elena's bicycle had a clean side strike on the front wheel, not the sort of damage a simple fall leaves by itself. A parent's phone video showed Daniel's sedan outside the lane. And then there was Pauline Vega's line. He looked at the back seat first. I wrote that down because it told me where Daniel's mind had been. The defense did what defense is there to do. Counsel argued the rain reduced visibility. Counsel argued Elena's dark coat made her harder to see. Counsel argued Daniel believed the crosswalk had cleared. One point gave me pause. The defense brought a specialist who said Elena had a mild weakness in that ear from childhood, the sort many people live with without noticing. I listened closely because law requires me to listen when causation thins. But her treating physician answered it in 6 plain words. Weakness is not the same as loss. The pause ended there. If something in what I have said so far has stayed in your chest, subscribe, because what I'm about to tell you next will stay longer. Subscribe now and then let me keep going. When Daniel took the stand, he tried to make himself smaller than the harm. That happens often. He did not deny driving onto the curb. He said, "I only meant to edge around the line." He did not deny seeing the crosswalk. He said, "I thought she had already cleared my side." He did not deny using Adrian Vale's name at the scene. He said, "I was trying to explain the urgency. A sentence can be polite and still reveal failure." Then came the line I wrote down and looked at for a long time before I moved on to the next page. He said, "I was just trying not to lose the best job I ever had." He said it as if the room would enter his fear. In one way, it did. I understood the fear. Jobs hold up families. Money keeps roofs overhead. But the sentence did something else too. It measured Elena's body against his job and told me which side he had chosen. A memory from my own life came back while he was speaking. I was 10, sitting on the floor outside my sister's bedroom on a July evening, listening while she practiced scales on a borrowed piano. The house was hot. My mother was in the kitchen canning peaches. Every time my sister missed one note, she started the whole line again. No anger, no complaint, just the same measure until it sounded right. I remember the hallway fan turning, and I remember thinking that a home can be held together by sound as much as by walls. I had not thought about that evening in years. Then I was back in my courtroom, silence. 2 came after Daniel's last answer. The prosecutor asked whether there was anything he wished he had done differently. He did not say, "I wish I had stopped." He did not say, "I wish I had seen her." He said, "I wish I had known one small move could follow her for the rest of her life." That was his last sentence, and when it ended, the room went quiet again. This silence was shorter than the first, perhaps 5 seconds, and had a different quality. Silence 1 came from pain being named. Silence 2 came from the room, understanding how Daniel had been thinking then and how he was still thinking now. He called it one small move. The room had already heard what that move cost. That distance between the size of the act and the size of the language settled over us. Then defense counsel asked to approach, and the quiet broke. Between the second silence and the verdict, one more witness gave a line that stayed with me. It was Pauline Vega again, called back briefly on rebuttal. The prosecutor asked what Elena had been doing while she waited for the signal that morning. Mrs. Vega said, "She smiled at the children first. That was all. No speech, no ornament. I wrote that down too. Sometimes the line that remains is not the one designed to last. It is the small one that tells you who a person was before harm reached them." Adrian Vale attended the second day of trial. I say that because his name had been used so many times it had become a kind of weather in the room. He sat in the back row in a dark coat with no one beside him, and for most of the day he looked at the witness stand. He did not speak. He did not ask for favor. Once, during Elena's testimony, he lowered his head and kept it there long enough for me to notice. That did not decide anything, but I marked it. Subscribe before I go further. I have more to tell. And the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. By the time closing arguments ended, I had heard everything the law was going to allow. The defense asked me to see a man who made one bad choice under pressure, not a cruel man. I did see that. Cruelty is not always loud. Sometimes it is simply the decision that another person can absorb the cost of your hurry. The prosecution asked me to see that pressure does not dissolve duty, especially in a school zone. I saw that too. When I returned to the bench to rule, I felt the third silence waiting ahead of me, though it had not happened yet. I had made my decision carefully, knowing that careful decisions and right decisions are not always the same thing, and believing that here they were. I found Daniel Mercer guilty on the main charge, guilty on the school zone violation, and guilty on failure to yield in the crosswalk. Adrian Vale did not move. He removed the building pass clipped inside his coat and placed it on the bench beside him. If you are still here at this point in the story, you already understand something important about why I am telling it. Subscribe. This is what I do now. I tell the cases that stayed with me. Subscribe and you will hear the rest of them. I began sentencing with the financial penalty because money was part of the case from the first minute. I said, "I am ordering you to pay a fine of $85,000 to the Riverton Hearing Recovery Fund." Then I explained why. He had used wealth by proximity as if it placed him above ordinary care, and so money needed to be turned back toward the harm his choices helped create. I said the fund provided hearing treatment, devices, and therapy for people who could not absorb those costs because another person chose speed over caution. I also ordered restitution in the amount of $21,400 separate from the fine. People often miss that distinction. A fine answers the offense against public order. Restitution answers the debt to the person harmed. I said that plainly because courts too often speak in language no injured person would use at home. Elena had lost wages, therapy time, transport costs, and the expense of equipment her classroom now required. Those bills were real before they were legal. Then I turned to the restrictive part. I said, "I am suspending your driver's license for 24 months, effective today." I told him why in plain words. There are choices that prove a person cannot be trusted with the road until time and conduct say otherwise. For 2 years he would not drive himself to work, or drive an employer, or make speed somebody else's problem. That was not vengeance, it was boundary. I ordered community service too, but not generic hours assigned by habit. I said, you will complete 400 hours at South Harbor Rehabilitation Center in the outpatient unit that serves people recovering from head injury and sensory loss after road incidents. I chose that placement because service matters only when it places a person near the human shape of what they did. Sweeping a warehouse would not have taught him what a changed life sounds like. Helping people relearn balance might. Then I gave the public and personal order. I said, within 60 days, you will deliver a written and spoken apology in the auditorium of Riverton Driver Training Academy before a room that includes student drivers, commercial fleet supervisors, and the staff of Vail Air Systems Transport Services. I said it had to be in his own words, reviewed only for accuracy. It had to name Elena Ruiz, the crosswalk, the school zone, and the fact that another person's ordinary morning was not his to shorten for convenience. And there was one more thing. I said, you will fund and provide within 30 days a full classroom assistive sound system for Ms. Ruiz, including wireless microphones, speaker balancing, and technician support for 3 school years. Then I told him why that part carried the greatest weight for me. The law had named the injury in her ear, but the real loss reached into her work, her students, and the daily labor of hearing what she once heard without effort. I could not restore what was taken. I could require him to support what she now needed in order to keep doing the work that gave shape to her life. After the orders, I spoke directly to Daniel, and I will say now what I said then. I told him that what he did could be measured in speed, dates, medical findings, and dollars, but it also had another measure. A woman standing in her own classroom turning her good ear toward children so she could still do her job. I told him that to his family I offered no accusation and no false comfort. They were not on trial, but they would live with what he had done. I told him that the position he held required care and judgment around other people's bodies, and he chose urgency instead. Then I ended where I needed to end. I said Elena Ruiz's life was not a delay in somebody else's morning. Subscribe if you are willing to carry this story past this video. That is what subscribing means to me, not a number, a person who will remember this. Subscribe. Now I can return to Silence 3 in full, because that is where all of this was moving. When the last word of the sentence left my mouth, the room did not breathe the way rooms usually do. Daniel looked down first. His lawyer set a pen flat on the table, as if sudden sound would be indecent. Elena's brother placed his hand on the back of her chair and did not move it. From where I sat, the air seemed to sharpen, not heavier, sharper, like the room had edges again. The silence lasted long enough for me to hear the building around us, a cart in the hallway, the vent above the jury box, a page turning at the clerk's station. Then it broke in the smallest way. Elena let out one breath through her nose and reached for the tissue she had not used all day. Adrian Vale stood, not fast, just fully, and when court recessed, he did not go first to Daniel. He crossed behind counsel table, went to Elena's brother at the aisle, and said, I should have come sooner. I was close enough to hear it. As the courtroom began to empty, I stayed seated for a moment longer. Daniel's mother moved first. She went not to her son, but to the rail, where she stood with both hands around the wood and looked toward Elena. She did not speak. Elena rose slowly, gathered nothing at first, and then said to her brother, I did not want him broken. I wanted him to understand. I have said that sentence back to myself more than once. When I finally stood, the room looked almost the same as before, except that every chair seemed slightly farther apart. One thing viewers may not know is how long a judge can remain seated after everyone believes the work is over. The clerk had stacked the exhibits. The bailiff had opened the side door, but I was still looking at the witness stand because from where I sat it still seemed occupied by the words that had just been said there. Courts are full of objects that return to themselves quickly. Chairs become chairs again. Microphones become metal and wire. A water pitcher becomes a pitcher. What takes longer are the sentences that named a life correctly for a moment. Those do not leave with the people. They stay in the room longer, and sometimes they stay in me. There are other people I want to speak for, other cases where someone needed a voice in that room and what they received instead was procedure. Subscribe and I will tell you those stories when I am ready to tell them. This was the first one I was ready for. The appeal came exactly when I expected it to come. Daniel filed within 28 days. The State Appellate Division heard the matter 9 months later, on August 18, 2025. They affirmed the conviction, the fine, the restitution, the service placement, and the license suspension. They changed one part of my order. In plain language, they said I could require him to speak publicly and take responsibility, but I could not dictate the emotional tone of his words. I thought that was right. Remorse can be required in conduct. It cannot be scripted into a heart. What I learned later happened on December 9, 2025. I did not learn it from a newspaper. I learned it from the service coordinator at South Harbor, who was in my courtroom on another matter and waited until recess to tell me. She said Daniel had finished a morning shift helping patients from the vestibular therapy wing to the transport van, and before he left, he carried a folding keyboard from one room to another for a child whose balance therapy included music cues. She gave me the date because she knew I would ask. I did ask. Then I thanked her and called the next case. The question this case left me with is not whether punishment matters. It does. The question is this: at what point does a culture teach a person that another human being can become part of the cost of being on time for somebody richer than they are? I have turned that over for a long time, and I still do not know the full answer. What I know is that grief and clarity are not opposites. One often produces the other if a person sits with it long enough. I have seen versions of this case before without the same names, without the same street, without a billionaire's shadow crossing the facts. A title changes, a company changes, a car changes, but the human math underneath can remain the same. One person believes urgency excuses care. Another person lives inside the remainder. That is not a lesson I'm handing you. It is simply what my work has shown me until I had no honest way left to deny it. To the people hearing this who have stood where Elena stood, I want to speak to one feeling I recognized in her face that first morning. It was not fear exactly, it was not shame. It was the strain of having to hold still while strangers decide how much of your altered life can be translated into words they will treat as real. I know that look. I have seen it before. If that feeling lives in you, I am not offering a slogan. I am telling you that I saw it when it walked into my courtroom, and I did not look away. To the people hearing this who have stood where Daniel stood, or close enough to know the ground under him, I want to ask one question I could not ask from the bench. What do you think your hurry is buying when it asks another person's body to pay? Sit with that before the next light, the next curb, the next moment you are tempted to borrow somebody else's status and call it reason. And if you need one concrete thing from me, here it is: leave earlier. That simple act has spared more harm than many speeches could. The hearing in Elena Ruiz's left ear never came back. I wanted to tell you about that because it is the one fact every order returned to and could not repair. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. Use the comments the way decent people use a quiet room after something true has been said.